But now, as we stand in the 10th year of its existence, it is critical that we pause and scrutinize whether this important legislation aimed at one of the most vulnerable sections of our society has achieved its carefully crafted objectives. And I say this deliberately because, at least on paper, if one reads the act, it appears that the law set out to do the right things in the right manner. If we were to look at the objectives that is reflected in its preamble, the act was meant to, one, effectively address sexual exploitation and sexual abuse of children, to prevent coercion or inducement of children into exploitative sexual practices, activity, and pornographic performances. Three, ensure that the law operates in a manner that is in the best interest and well-being of the child, which ensures healthy physical, emotional, intellectual, and social development of the child. And fourth, protects and respects the right to privacy and confidentiality of a child through all stages of judicial process involving the child. Therefore, if we look at the law itself, it appears that it took into account both prevention of the crime itself, as well as protection of the child through various stages of judicial and legal interventions once the incident occurs. It is this part that is the focus of the report that we are going to launch today. How have special POCSO courts established under the legislation fared in upholding the objectives of the Act? It is this central question that brought together Jaldi team at Vidhi. We are a bunch of legal researchers, and the exemplary team at the Dijori project at World Bank, which has expert economists involved in interdisciplinary research. And as with the making of the POCSO legislation itself, this study was not an easy one either. It has taken collective effort of all the co-authors of the report, supported by multiple researchers and interns over the last 1 year to make this study finally public. We are thankful to all of them who have been a part of this effort. With this, I invite Mr. Daniel and Ms. Shireen from the Dijori team at World Bank to say a few words before we go into the report. Daniel?
Hi, my name is Daniel Chen, and I lead the Dijori program, which stands for Data and Evidence for Just Reform. We're a team of lawyers, economists, and computer scientists, and our aim is to revolutionize how legitimacy and equality in justice systems are measured, understood, and enhanced. And we decided to partner with Jowdy for the study to bring data for this assessment of the POCSO Act, which previously lacked rigorous data due to the lack of data. And our colleague will later be describing the breadth and depth of our study. I really do hope that we will be able to continue to work together in partnership with the judiciary and the government on potentially implementing the suggestions in this project. So thank you so much.
Thank you, Daniel.
Shireen.
And thank you, Deepika, and thank you to all of you organizing today. We all came together for this report with a shared interest in studying courts and society. The project was truly interdisciplinary. As Daniel said and Deepika said, there were many of us from different disciplines, different skill sets, and each of us brought a very unique vision to the project of what we thought we would end up exploring. The end result is, in some sense, an illustration of the idea that the sum is bigger than the parts. I think each of our visions, each of our skill sets found a place. This is truly the power of interdisciplinary collaboration. And I look forward to more conversations about what it all means and where we go from here. Thank you to all of you. It's a pleasure to be here.
Thank you, Shireen. Thanks, Daniel. Now, if I may invite all the panelists to come on the podium for a ceremonial launch of the report. Justice Joshi, Dr. Bajpai, Mr. Damle, and Mr. Asthana. And of course, the co-authors of the report, Sandeep and Apurva. Thank you so much. The report will now be available on the Wiki website. Copies of the report will also be available for you all to take away at the end of the program. We will try and make the raw data that was relied on for this study on Wiki website on Jaldi portal in the coming weeks. Thank you, Justice Banerjee and all the panelists for launching the report. We will now go into presentation of key findings of the report by Apurva and Sandeep, who are the co-authors on the report.
Thanks, Deepika. Thank you all for being here, and thanks also to the people joining us online. This is a short presentation, and we intend to just give you a brief overview of the report, highlighting the challenges, findings, and recommendations that we came up with. The aim of this report was to assess the judiciary's role in the implementation of the POCSO Act 2012. The quantitative evaluation is really based on the eCourts data that's available. eCourts is, of course, the online portal for availability of the district court cases, metadata, judgments, and various other aspects of the case, procedural mostly, which was launched early in the 2000s. And so the basis of this act is most of the cases coming from about November 2012 to February 2021. Now, as you can see from the map alongside, the scope of this case data is actually exceptionally large, perhaps one of the largest in this field. It covers about 28 states and union territories, about 486 districts. And in all, we compiled a data set of about 400,000 cases, or 4 lakh cases. Now, to answer questions that we had intended to study in this report, we used a subset of that, which is about 230,000 cases. So just from these numbers, you can see how vast the scope of this report is. Finally, the report has a tripartite structure. We essentially start with quantitative aspects, the process of cleaning, collecting, and organizing this data, along with the analysis. And in addition to this, we also looked at more than 100 sample judgments and actually read through them to understand certain qualitative aspects of the case content. The second part of this analyzes the jurisprudential evolution in the field through case law analysis of High Court and Supreme Court cases. And finally, the third piece, where we wanted to get an understanding of how it's being played out in the on ground. So we do this as part of a study of previous policy interventions, as well as extensive consultations with stakeholders in the field. We wanted to start with challenges of working with the eCourts data, because anyone who has probably worked with them will know this has to come first. The first problem, next slide, please. First problem is that the data is exceptionally messy. So, of course, some of the panelists can attest to this as well. There are multiple challenges with working with this data. To illustrate a few, we have the following, which is that even for the POCSO Act, which potentially is a small kind of act by case load, we see that there are about 688 ways in which the act has been referred to in the eCourts data. So that in itself presents a huge challenge to actually get the cases associated to this act. Next, you can see that there are about 1,000 case types. Most of the eCourts data deals with procedural aspects like case hearings, when they happen, and the content of the case hearings. And you can see that there are about 2,700 odd recorded purposes of hearings. And finally, the case outcomes themselves, or what we call the disposals, they're recorded at about 700 odd variations, which we actually reduced down to 7, right? So in our analysis. So you can see that due to all these challenges, we essentially had to remove some of the cases. About 50,000 cases had to be excluded because even though they were tagged with the POCSO Act, they really had nothing to do with the POCSO Act. So for instance, you might have also the civil suit, or you could have negotiable instruments acts applied. And so they really are not exactly about POCSO. Another chunk of them had to be removed because these cases were just unintelligible. So we didn't know what they meant, or the case types did not make any sense. So all in all, about 17% of that data was unusable. Finally, to answer questions that we were interested in, we had to remove some of the cases which were fine in terms of categorization, but for instance, could have been about bail, which we had to discard. So all in all, we have about 230,000 cases that we studied. Now, the second aspect, which is, I think, a little more subtle in some ways, is that the data is limited. So despite the voluminous quantity of data that we already illustrated, it is lacking in some way. So a certain kind of granularity is missing. So next slide, please. We kind of know a lot about the procedural aspects of the case, but what exactly happened in the case is missing. Here's a schematic where we have a heat map. One way to interpret this is that each square that you see is actually a bucket of cases, a certain collection of cases, which have, in this case, either an IPC or a POCSO acts and sections applied. So if you look at the horizontal and vertical directions, you'll see which two acts are applied. So one particular example I'd like to draw your attention to is that, for instance, if you look at IPC 366, which is along with POCSO sections 5 and 6. So IPC 366 refers to kidnapping with intent to marry, and POCSO 5 and 6 refers to aggravated penetrative sexual assault. So in this case, although they have these two cases applied, we don't know which is a genuine kidnapping, genuine in quotes, or it's a case where maybe a couple has eloped and the parents have filed a case. So in order to actually delineate between these two, we don't really have much information to actually get to the case content. So we started this whole section and presentation with data challenges because we want to temper and caution against strong conclusions and to view the report in light of the somewhat poor data infrastructure that we have at hand. So with that, I ask Apurva, our co-author, to talk about the results and key findings.
Thanks, Sandeep. Good evening, everyone. Thank you for being here. Since Sandeep gave you the caveat about drawing strong conclusions from the data, I would want to start with another caveat. Our study looks at the performance of courts in the implementation of the POCSO Act. However, we've tried to map stakeholder interactions across the system in our study, and we find there are numerous actors. It's not just about courts, prosecutors. There is the police, there are FSLs, there are support persons, there are child welfare committees, there are juvenile justice boards. There is a mirage of actors out there. And while our study looks at only the performance of courts and sees how the performance of courts can be improved, it is important to remember that courts are a small part of the complex maze that is the child protection system in India. Next slide, please. This brings us to our key findings. With this caveat, I would like to move. Our first finding relates to the reporting of cases on eCourts. There's another caveat here. Reporting is not equivalent to the incidence of these cases. In cases of sexual offenses, which are generally underreported,
There is greater reporting may signify that more people are actually using the law. With this caveat, we come to the findings. As findings are for this particular aspect are split into two parts. On the left, you see a map which shows you how reporting of cases on e-courts varies across districts. And from the lighter to the dark, you can see how the map differs. This shows you how different districts report POCSO cases. Further, the map on the right shows you the cases which show you the districts which report the highest number of POCSO cases. Namchi in Sikkim has the highest number of POCSO cases reported, with over 500 cases reported. And this is when all of this has been adjusted for population. New Delhi comes second with over 350 cases reported per 100,000 population, and Central Delhi is third. Move on. Our next finding shows the impact of the COVID-19 pandemic on POCSO. This graph shows three things. First, the total number of POCSO cases in different years. Two, the number of pending cases, and the number of disposed cases across years. As is visible from the graph, the number of total POCSO cases has risen year on year, whereas the number of pending cases has also risen. However, if you see the dots on top of the bar graph, you will see that there was a declining trend in the percentage of pending cases from year to year. However, the last dot shows you that there was a steep jump in 2020 in the percentage of pending cases. This is evident if you just look at the numbers. There was a sharp rise of 25,000 POCSO cases in just the year 2020. The number of disposed cases was on an increase till 2019. However, in 2020, it dropped by 10,000 cases. Next slide, please. Another way of looking at pendency figures is to examine how states are performing. Pendency percentage varies starkly across states. Like the previous graph, this graph shows three things. First, the total number of cases state-wise. Two, what percentage of these cases are pending? And three, how many of these have been disposed? What we find, the total number of cases is highest in the state of UP, with 40,000 cases, and lowest in Tripura, which records about 250 cases. The disposal percentage is lowest in the state of Himachal Pradesh and highest in the state of Tamil Nadu at 80%. Among the large states, Uttar Pradesh has highest pendency with 3/4 of the POCSO cases pending. Our next finding pertains to the time taken for disposal. We have looked at time in two ways. One, in terms of the average number of hearings, and two, in terms of the average case length. What do we mean by average case length? Average case length refers to the time it takes to dispose of a POCSO case in the number of days. To put this in context, I would like to refer to Section 35(2) of the POCSO Act, which talks about the fact that a special court should try to dispose of a POCSO trial in less than 1 year from the date of cognizance. Is this happening? Clearly not. The average case length varies between states, where in Himachal it's about 2.5 years, and it's lowest in Chandigarh at about 7 months. The average number of hearings varies from about 11 in Kerala to about 31 in the state of Gujarat. Now, Himachal Pradesh has the highest case length at 2.5 years. Why is that so bad? The POCSO Act prescribes 1 year, but that's as far as possible, right? It's problematic because our data set includes transfer cases. 1/5 of this data set includes cases of transfer. And transfer cases will not consume a lot of the court's time. So this data is skewed by the percentage of transfers, and this means that the average case length is a lot higher. To understand how the average case length applies in cases that have actually been through a full trial, we look at conviction and acquittal. This scatter plot shows the time taken in acquittal and conviction across states. In most states, the time taken for conviction is longer than the time taken for acquittal. The mean case length in acquittal cases is longest in the state of Himachal Pradesh at about 3 years. So 3 years to acquit on average. And the shortest in Chandigarh, which takes about 6 months on average. The mean case length in cases of conviction is longest in the state of Delhi, which takes about 3 years and 9 months on average in a case of conviction. It is shortest in Chandigarh, which takes about 10 months on average. This is clearly longer than 12 months. Our next finding pertains to the nature of disposal in POCSO cases. For our analysis, disposals have been divided into 4 categories: acquittals, convictions, transfers, and others, which include all other outcomes. Our finding is that for every conviction, there are 3 acquittals. Convictions comprise just about 14% of the disposed cases, while acquittals form about 43%. In most cases, in most states, there is a huge gap between acquittals and conviction. In Andhra Pradesh, acquittals are 8 times more than convictions. In Kerala, the gap is not as wide. Acquittals are 20% of total disposals, whereas convictions are 16%. The next set of findings deals with the evidence stage. Putting this in context, Section 35(1) of the POCSO Act provides that the victim's evidence has to be recorded within 30 days of cognizance. And if that is not done, reasons are to be recorded. What we see is that most amount of time in a POCSO trial is being consumed by the stage of evidence, which is about 40%, both in number of days and in terms of number of hearings. Evidence is an important stage. It requires examination of witnesses, it requires cross-examination of witnesses, there is expert testimony, there is so much that happens in this stage. So why is it problematic if evidence is taking 40% of the total time? It's only problematic, 1, it violates the act, and 2, it is problematic for the victim. Evidence is one stage that requires some participation of the victim, necessarily requires participation of the victim, and subjecting a victim to 6 months on average of evidence in a POCSO case is unfair. The only stage second to evidence is the stage of charge, which only consumes 10% of the total number of days. For our study, we wanted to see how different provisions of the POCSO Act are applied and how this has varied over time. What we found is that it is Section 3 and 4 of the POCSO Act that is most frequently used. 31% of the cases that we studied corresponded to this. The next most used provision of the POCSO Act is aggravated penetrative sexual assault. So what you see is that a majority of POCSO cases correspond to some of the most heinous crimes that the Act talks about. The lowest number of cases are cases of aggravated sexual assault. Further, what we notice is that offenses falling under all the categories we've identified are increasing year on year. That brings us to our last finding. We also wanted to understand whether the percentage of acquittal and conviction varies across different offenses. Our finding was that it doesn't. There is no significant variation between acquittal and conviction percentages for different offenses. While for penetrative sexual assault, the convictions are at about 21%, whereas in aggravated sexual assault, convictions are at 26%. However, convictions are lowest in cases of sexual harassment at about 18%. This brings us to our key recommendations. What do we need to do? Make POCSO data more accessible so that we can understand what is happening at the ground level through the lens of data. Improve the accuracy of data. Sandeep has highlighted how problematic the data is. It took us months on end to clean this data. It shouldn't be so hard to study how crucial law, which protects some of the most vulnerable sections of our society, is functioning. This improving accuracy of data can enable data-driven policymaking. We've seen that all is not lost. There are some states who are performing better than others. Chandigarh, for instance, What is needed is that we need to transfer learnings across states. We need to provide, while we need to provide transfer of learning from one state to another, especially the best practices, we also need to account for the specific needs of a particular district. As I showed in the beginning of our presentation, there is huge variation in how these cases are reported on e-courts across districts. What we need is a district level response. Further, the purpose of showing the stakeholder mapping was to show that we need integrated capacity building programs. Our consultations show us, tell us that there is a lack of coordination between different actors who do not appreciate and understand the role that the others play in the system. For this, we need these capacity building programs. Further, we need to assess legislations like POCSO periodically. This should not be a once in 10 years exercise. It has to be more frequent so we can understand what is happening on the ground, what is working, what is not. We would like to leave you with the cover page of our report, which shows that children are at the center of the POCSO ecosystem, as they ought to be. Thank you.
Thank you so much, Apurva and Sandeep, for that hard-hitting presentation. I'm sure everyone in the audience is keener now to get their hands on the report. The data points highlighted, just to quickly summarize, it feels like it raises questions on several fronts. On the one hand, it is about perhaps the fact that substantive provisions of the legislation itself require some rethinking. Say, for instance, how adolescent consensual sexuality is perhaps criminalized and has become a weapon of sorts for people who oppose certain kinds of relationships. And on the other, perhaps it also brings into sharp focus whether the practicality of the timelines that have been imposed are accurate, are driven by any scientific data. Perhaps there is a need to revisit those timelines as well. And also it brings into sharp focus the capacity constraints of various actors involved in the child protection ecosystem, who are involved in various stages of the trial and investigation. So to add to this, and perhaps to encourage nuanced understanding of how POCSO has fared over the years, I now invite Justice Banerjee to give keynote speech and help us understand what is happening on ground, and perhaps also go into understanding what has gone wrong and what can be done in the future to course correct. Justice Banerjee.
A very good evening to you all. There can hardly be any doubt that children are the world's most valuable resource and its best hope for the future, to quote President John Kennedy. They are the national asset. Children are vulnerable. They need to be molded. The children of today are the citizens, the adults of tomorrow. The future of society, the future of the country, and the future of the world, I would say. Every country depends on its children, how we bring the children up. Sexual exploitation, sexual abuse is undoubtedly a violation of human rights. It's violence against a child. It can destroy a child psychologically for all time to come. We find from the data that there has been an increase in the number of POCSO cases. More and more children are being sexually exploited. But the question is, are really more and more children being exploited sexually? Or is it that there is more awareness amongst the guardians, the parents, and people are coming forward to complain? I think sexual abuse of children, the crime, it was a crime which existed in society for a very long time. But unfortunately, it was brushed under the carpet for social reasons. Very unfortunately, I wouldn't say till recently, but maybe even now, often it is the victim who has to go through the stigma, through criticism. I will, before proceeding further, have to be very honest. When Deepika asked me to deliver the keynote address, it was based on a statement I had made with regard to consensual relationships, consensual sexual relationships between adults. But so far, as facts and figures, the actual reasons, the impediments in the trial courts are concerned, they are more based on knowledge rather than on experience. I can just give you one example. There is an incident which still sends shivers down. At that time, of course, the POCSO had not been enforced. There was a program on gender sensitization. In Calcutta High Court for about 4.5 years, I happened to be the only woman on the bench. And whenever there were sensitization programs, legal awareness programs, I was taken along. There was one which was being co-partnered by Swayam, a women's organization. There was this girl who was possibly 16 years of age when I met her. She did not have parents. When she was about 14 years of age, a so-called aunt allured her to go to Bombay, gave her the assurance of a job, told her that she would have lots of money. All that she was expecting was 4 square meals, which she did not get because she herself was living with an aunt, being an orphan. She decided to leave without telling her aunt. She thought she would give her aunt a big surprise by giving her money, taking care of her. She landed up in a brothel. She was sold. Fortunately, she was rescued with the help of a client who had heard her story and somehow helped her to escape. She was handed over to a journalist and then to the NGO. She just held on to my hand. You know, this girl, from day one, she had to entertain multiple partners who insisted on unprotected sex. She contracted it. She became pregnant. She lost her child. She contracted HIV. And in this program, she just caught my hand and she said, I want to live. What wrong have I done? I only wanted to earn a living for myself. She was trafficked, tricked and trafficked, one would say. This is so common in various parts of the country. I was associated for a long time with the Calcutta High Court Legal Services Committee, and then later the officiating chairperson of the West Bengal Legal Services Authority, where I came into touch with a lot of victims. West Bengal was a source of trafficking. It was a destination for trafficked women. And it was also a transit point for people who were brought in from Nepal, Bangladesh, and taken to various other places all over. Most of them were minors. Most of them were children. I'm not aware of all the facts and figures. "10 years of enforcement of the POCSO. On the 13th and the 14th, I was at the National Judicial Academy at Bhopal, where I was invited as a resource person. I was reading the newspapers, possibly on the 14th morning itself. What do I see on the first page? A 5-year-old girl raped in Kolar who died, and another rape of a 9-year-old, investigation under process. With the implementation of the POCSO, there has definitely been some headway because procedures have become more child-friendly, at least in some parts of the country. I have direct experience of West Bengal, Delhi, and Tamil Nadu, because I was a judge of Calcutta High Court, later judge and executive chairperson of the Delhi State Legal Services Authority, and then Chief Justice and Patron-in-Chief of the State Legal Services Authority of Tamil Nadu. In Tamil Nadu, a reference was made to a larger number of disposals. There are special courts. There are multi-purpose centers for children where statements of the children are taken. You know, one major problem with children is if you keep asking them about their traumatic experience again and again and again, it causes them a lot of trauma. And then with the smaller children, there can always be inconsistencies. I think if I were cross-examined right and left, I would probably also falter at one point or the other and think, of a small child who's being asked the same question over and over again. So earlier, what used to happen is that a statement would be made maybe to a lady police officer in the presence of a social worker. Then the doctor, the psychiatrist, and then the court. By the time the child would have to give evidence all over again, she would be nervous, she would be exhausted. Probably the last evidence, which would be the evidence in court, she would falter. And as a result, the case, that would affect the result of the case. Today, the training, the judicial academies, both at the state level and the National Judicial Academy, is regularly conducting training programs for judges on how to deal with these POCSO cases. They don't have to be taught the law because judges do know the law, but they need to be sensitized. Speaking for myself again, I can say, I was so immensely close to my father. I could never have imagined that any father could possibly have sexually exploited a daughter. It was only in one of the legal camps that I actually met a victim of sexual exploitation by her own father. Very often, children are exploited. It may be rare, but it does happen. Children do get exploited even by fathers. But getting exploited by relatives, getting exploited by cousins is quite common. But usually, such incidents are hushed up. Either because both the perpetrator of the crime and the victim belong to the same family, or for the reason that it may bring disgrace to the family, embarrassment to the family. The next vulnerable group of children are those children who are, in a sense, children in need of care and protection. Children who have to be left to themselves the whole day because their parents have to leave them alone to fend for the children, to take care of the children. Such children often get exploited. With consciousness today, complaints are lodged. But after a while, either the parents get bought over or the parents are threatened. And ultimately, the evidence has to come from the complainant or the victim. So when they shy away for various reasons, there is difficulty so far as the court is concerned. There are certain provisions also which require some amount of thinking. Reference has been made to one, that is consensual sexual relationship between minors. There could be a consensual sexual relationship between two classmates. one of whom could be just above 18, and the other could be 17 years and maybe 9 months. When cases like this come to us, come to the court, I would say it doesn't come to me any longer. I retired 2 months, 1.5 months back. We are in a dilemma. The law is clearly against them. A person below 18 cannot give consent. Who is the complainant? More often than not, it is the family, because the boy is not settled, or for reasons of inter-religion affairs, inter-caste affairs, inter-community affairs, so on and so forth. I had a case which had come up. I had to exercise the power of the Supreme Court under Article 142 to do complete justice. Although strictly speaking, the power under Article 142 cannot be used against the law. Where the law is silent, the power can be used to do complete justice. This was a case where the two had had an affair. They had had consensual sexual relationship, which had perhaps ended up in a pregnancy, which was aborted at that point of time. They later got married after they both crossed 18 years of age. But the case, which was initiated by the family when the girl was a minor, followed them even after they had been married. Now, if we just look at the punishment for penetrative sexual assault defined here. Very difficult to get bail. So when a boy 18 years of age or 19 years of age is accused of an offense, he may ultimately get acquitted, but he's finished. It may affect the relationship between the couple also in the long run if there is so much of strain between them. If the relationship still survives, which is well and good. I personally feel that the law requires to be amended. Whether it should be Romeo-Juliet kind of law, which they have in some states in the United States, I cannot say. But so far as the Juvenile Justice Protection and Care Act is concerned, there has been an exception made in case of children over 16 years who are accused of heinous crimes. If the board considers it necessary, they may be referred for trial in the same manner as an adult. There can be a similar provision that where there has been a sexual relationship which is consensual, where there has been a romantic relationship, there should be an exception if the girl is over 16 years of age. Maybe, there could be some age bar, some cutoff. Now, if we just look at the statement of objects and reasons, it was proposed to enact a self-contained, comprehensive legislation inter alia to provide protection of children from the offenses of sexual assault, sexual harassment, and pornography, with due regard for safeguarding the interest and well-being of the child at every stage of the judicial process, incorporating child-friendly procedures for reporting, recording of evidence, investigation, and trial of offenses, and provision for establishment of special courts for speedy trial of such offenses. As has been pointed out, evidence has to be taken within 1 month. Trial has to be completed within 1 year. But I think the newspapers reported that the global population has now reached 8 billion, and the population of India has surpassed that of China. China had the largest population in the world. The courts are burdened. There are many cases, and there are other difficulties which I pointed out, because the child also has to be prepared to give evidence. When the child is very small, very young, when there is medical evidence, conviction becomes much easier. But in other cases, having regard to the criminal jurisprudence in this country, where a person is presumed to be innocent unless proved guilty. Of course, the standard is a little different in POCSO cases. But nevertheless, the case has to be established. Unless the case is established, I think I've run out of time. I had only 15 minutes. Yes. So this is one issue. The second thing is the provision for compulsory reporting. This also needs some amount of thought, because in some legal awareness camps where we used to advise parents and others to report these cases, they raised various issues. Now, compulsory reporting, if the child does not want it, will it not clash with the right of a child to privacy, when the right to privacy has now been declared a fundamental right? These are also, questions which require some thought. I think apart from strengthening the law, there has to be quicker disposal. The wrongdoers have to be punished. A large number of acquittals may embolden people. But what is really required is sensitization to the issue at all levels, at the family level, at the school level, institution level and everywhere else. Since this is a topic I'm very passionate about, I could have just gone on and on and on, but we have experts on the panel whom I'm also very keen on hearing. And I'm sure Justice Joshi is in a much better position than me because she was associated with criminal law much more than I was. Thank you very much. If you have anything to ask after the panel discussion is over, maybe you can put questions which I'll try to answer.
Thank you so much, Justice Banerjee, for sharing your experiences and giving us a reality check on the various pushes and pulls within the system, which affect everything right from how perhaps cases get reported and how ultimately judges are put in a spot when it comes to decision making. And going back to the point we started with, we perhaps need to revisit certain substantive provisions of the law itself and the capacity of the stakeholders in delivering the true objectives of the Act, which is protection of children from sexual abuse. With that, we will go into the segment of panel discussion, which I'm also eagerly looking forward to. We have a stellar panel with us today. Justice Shalini Pansalkar Joshi. Dr. Joshi is the former judge of Bombay High Court, having retired with experience of more than 3 decades of working as judicial officer in various capacities as principal judge of City Civil and Sessions Court Bombay, District and Sessions Judge Court at Pune, Special Court for Trial of Cases of Atrocities Against Women, Principal Magistrate of Juvenile Justice Board. She's done her master's and doctorate in laws from Pune University on the subject of child sexual abuse, looking at it from socio-legal perspectives. We also have Dr. Asha Bajpai. Dr. Asha Bajpai is the former Dean and Professor of Law of the School of Law, Rights and Constitutional Governance at TIS, Mumbai. She has a PhD in law with specialization in child rights. Her PhD thesis was on the best interest of the child in the Indian legal system. She's been involved in teaching, research, training, and legislative reforms for more than 2 decades. Thank you for joining us, Dr. Bajpai. Then we have Mr. Anand Kumar Asthana. He's a child rights lawyer and trainer on various child protection laws and policies. He has been an advisor to Delhi Legal Services Authority on victim compensation to children and served on multiple committees to study the functioning of observation homes, etc. He has also published on Juvenile Justice Act and the rights of the child. Mr. Devendra Damle, he has spent majority of his professional life working as a public policy researcher at NIPFP. His areas of work include regulatory governance, judicial administration, and property rights. He's particularly interested in empirical, data-driven studies of the law and public institutions. Devendra is currently working with the policy team at ONDC. Thank you so much, all of you, for joining us for this discussion. Let me just come on to the dais to continue the discussion. I would actually like to start with where Justice Banerjee gave her concluding remarks, which is regarding the difficulty that the judges often face in light of complicated factual scenarios which are often not as black and white as we perceive to be, especially in the context of POCSO legislation. So I would direct this question to Justice Joshi, and it would be great to have your remarks on the sort of elephant in the room, right, regarding consensual relationship between adolescents. Having been in the district judiciary and then having dealt with similar cases, perhaps in the appellate side in Bombay High Court, how do you see these cases as a judge, and what do you think should be the way forward for policymakers on this issue?
This is really a gray area under the Act, because the object of the Act was to protect the children, not to punish or criminalize or stigmatize the children, whether they are of the age of 16 years, 17 years, 18 years. And that is happening in these romantic relationships, because both of them are falling in love with each other, eloping, getting married, having children, and then they are being prosecuted. The girl, if the parents are opposing it, then the girl is kept in the institution and the boy is prosecuted. And that is really sometimes, as a judge, we find it very difficult to deal with this situation, because we don't want to punish the child merely because he has fallen in love. Falling in love is not an offense. It can't be. It is just a growing up process. It is a part of growing up process. And with our archaic or, moralistic concept, we always feel the girl to be victim and boy to be a criminal. Why so? When both of them have fallen with each other, it is a romantic relationship. And then, every high court, if you know, around 24.3% of the cases filed in the court are of romantic relationships. So you can imagine quarter of the cases. And in all those cases, we are faced with the dilemma, as Madam has said. All the high courts from Meghalaya, northeast to the southeast, to the south like Karnataka, Kerala, Bombay, Allahabad, West Bengal, every high court is expressing grave concern about the same. They are finding creative ways to deal with these cases. They are interpreting the provisions in a way to further the object of the Act. Like Calcutta High Court, they said that penetrative sexual assault means only when there is unilateral act of assault, and not when both of them, it is a union of body or souls out of love and affection, and therefore such case cannot become an offense under the Act. The other high courts like Karnataka or Kerala have suggested creating awareness in the children about the drastic consequences of, having such sexual relations or falling in love during that adolescent age. But in my opinion, it will not be enough creating awareness, because India being an adolescent country, we are the youngest, we are having the youngest population in the teenage area. And with social, we know the children getting exploration at very early stage. And that, as Madam rightly said, we are recognizing it in Juvenile Justice Act. So why not recognize here also? Especially when the bill was presented, and that is something we have to remember. When Women and Child Development Department has presented the bill in the Parliament, they have put the proviso to cover these cases where there is consensual relationship and the consent is not obtained by deceptive means. But then Parliamentary Committee did not accept it, maybe because of the several other considerations. But even UNCRC Convention on Child Rights also contain a general comment 20 stating that such relationships should not be criminalized. It provides for decriminalization of such relationships. So what is at most required is a legislative intervention. Firstly, because unnecessarily the children are being harassed, traumatized during this entire process for no fault of them. Secondly, because the courts are overburdened. flooded, dockets are flowing with the cases, and most of the time is, spent, resources are spent in deciding these cases. As a result, the cases which really require the focus and attention, where the child is really, small, less than 16, and there is exploitation, sexual abuse, sexual assault, those cases, are not disposed of at the earliest. And therefore, we have to find out some ways. We can't have a uniform or straitjacket formula, uniform law for all the children from 0 to 18. I mean, the legal protection required for a child of 2 years, 6 years may be different from the legal protection required for a girl or boy of 16 to 18. So we have to mold the law. We have to make the changes. And I'm happy to note that there is a SLP pending in the Supreme Court, in which the Supreme Court has issued the notice on 29th of March 2021, and asking the legislature to file it, say, about the necessary amendment to be made in the law, so that either there can be exception or we can increase the age of consent from 16 to 18. So really legal nuances are necessary, because we are unnecessarily criminalizing these youngsters who are falling in love.
Right. Absolutely. Thank you so much for sharing your conclusive opinion on that, and sharing so many data points along the way. I think what will become necessary for us to be mindful of this facet of interpretation, which, as you rightly said, falls in the gray area, while looking at data that we presented early on. When we say there are 3 acquittals for every 1 conviction, perhaps what we also need to read along with that data are instances such as this, which will help us understand the ground realities. And speaking of ground realities, what is also equally important, as was highlighted during the presentation, is to look at the role that other stakeholders within the child protection system play, ranging from support persons to special public prosecutors, to the persons who train these various stakeholders in academies, etc. What we have learned during our consultations as part of our research process was that there is real dearth of capacity building across all levels for these stakeholders. Mr. Asthana, I pose this question to you as someone who's a practicing lawyer, who's a child rights lawyer. How do you see this capacity constraint, and what has your on-ground experience been like? Oh, sure.
I think capacity is something which we can keep investing for years and decades. It will always remain a constant need. But in case of POCSO, what I feel is that the kind of radicalism in the provisions which POCSO introduced, our judges are not ready for that, right? And I don't see also very genuine effort beyond sympathy and love. So that's fine. The kind of innovation which is required, the kind of hard work which is required in terms of taking out time from additional charges. In Delhi, we may have sufficient number of POCSO courts, but in large part of the country, POCSO for a very large time remained an additional charge. So if you have to prioritize, you will always see other serious stuff, for example, CBI court or any other commercial court, always taking precedent over POCSO related cases. So it's not just a matter of capacity building, it's also how genuinely judiciary warmed up to rolling out this law and putting its entire might. I see lawyers struggling day in and day out, trying to get these provisions implemented. But somehow I feel that the kind of effort judges should take, and here I say both, not just the district judiciary, but also superior courts, because the nature of our judiciary is very conventional. Unless prompted by a high court judge, unless prompted by Supreme Court judgment, our judges don't innovate. So that has been my experience that these provisions need little more active engagement. Did I answer that?
In part, yes, but I think we will go into capacity building as we get along with the conversation. But thank you for that perspective, because there is no point talking about how the courts have fared if there are no judges actually sitting in those special courts. And our data does tell us that constitution of special courts and appointment of special public prosecutors in some of these courts also came to be extremely delayed. And the Supreme Court has time and again observed the requirement of timely manner in which these infrastructural requirements are catered to in different states. But while we do understand that there are capacity constraints, there are improvements that need to be made along the way. As we stand here again in the 10th year of POCSO legislation, I think it is also equally important to sort of look at how far we have come. As Justice Banerjee also alluded to this, there are now child-friendly procedures that are there. And this is where I would like to invite Dr. Bajpai, who has been studying this for decades now and is perhaps one of the very first researchers to have written on this topic. While the data does present a bleak picture of ground realities, how do you think things have changed on ground before and after POCSO?
Thanks, Apurva. Yes, it has really been a long journey from the time we had Indian Penal Code provisions relating to child sexual abuse, the IPC provisions of 1860, which were like colonial provisions, which focused on morality, virginity, and they used to focus on abuse, injuries, consent. And that was the rights of the child at that time were nowhere to be seen. So we began with that. We began with the IPC provisions. And as we go along, as we come in the 10th year now, how we came towards POCSO, the framework was gradually built. The framework was gradually built. It has not come overnight. The framework was gradually built through various judgments in the courts, through various researches that happened, through various law commission reports that came in, and also criminal law amendments that happened all along the way. And also we had what we call training programs, capacity building programs that had happened. I think it was, and also government also came up with a law, the bill that was presented. So with all the efforts and the NGOs in the field, the NGOs have intervened several times during this whole journey that is there. Very quickly, if you'll permit me, I would like to very quickly see how it all began through the framework, how it was laid down. I think it was 1957 when the first judgment came, where a school teacher, a 39-year-old school teacher, his punishment was enhanced because he had molested his student. So that time, and the court said, at that time, 1957, it was, I think, Ghanshyam's case. The court said that this punishment has been enhanced because the accused is a person of trust and authority. And that is why we have enhanced the statement. That's the first beginning I see how we came towards this framework that was there. Then we had this 7.5-month-old child, a baby, whose modesty was outraged, and Section 354 was applied in that case. When 354 was applied, when it came before the court, the modesty was not defined, has not been defined, and the court said a 7.5-year-old baby doesn't have modesty. So that is how it came in. Yeah, that is how we began. After that, we had the 42nd Law Commission report. In the 42nd Law Commission report, they did mention that, yes, we need to look at it. Nothing more was done in that. After that, I now would like to bring to light the Mathura rape case, which all of us are aware of. What happened in the Mathura rape case? The two burly policemen who had raped a 16-year-old tribal girl in the police station, was let off. Why? Because they felt there were no bruises on the body. That was how 1860 colonial law was. There was no bruises on the body, there was consent, and she was habituated to sexual intercourse. Now, this issue about habituated to sexual intercourse is still there. In 2010, also, when we had that matter, when we got reports from the medical team, habituated to sexual intercourse, small children, intellectually disabled children, habituated to sexual intercourse. It's still going on. Then I would like to quickly come to the Mathura rape case, huge protest, public outcry when the policemen were let off. Open letter to the Supreme Court was written by some academicians. And because of that, you had the 1983 Criminal Law Amendment Act, which amended the rape laws, the Criminal Procedure Code, also the Indian Evidence Act. Gradually, we are moving towards POCSO. That's what I was trying to say. 80s, there was judgments on condoning delay in filing FIR. Why? Because it is a matter of family honor and it takes time to decide to come to the police station and file an FIR. So you condone the delay. This was what was laid down. Then you had corroboration not necessary in those cases. And then you had, now you have, we had this Sheila Barse's case, where we said that reputation and character is not relevant. It was there in Mathura's also, but history later in the amendment was not, but still it came up. And still the court reiterated that reputation is not necessary. I would like to talk about section 377. Since there was no law for child sexual abuse, you had section 375, 376, 354, 509, only for the girls or women in mind. 377 was used in that Brinkman helmet case that came in 377. And this 377, the manner in which the 6-year-old, that boy was, cross-examined in the court. The carnal intercourse against the order of nature could not be proved. It is not easy to prove section 377. And that is why that boy did not get justice at that time. Another very, very important case, very quickly, was the Freddie Peets case. I still remember in the Freddie Peets case, these were children on the beaches of Goa who were lured into the shelter home by these foreigners, and they abused them through nude pictures, pornographic pictures, and they transmitted these pictures so that the others also enjoy them, as they call it. Now, when this happened in Freddie Peets' case, I remember the children were so scared. They were so scared to come before the court and talk to someone who had given care, who cared for them. I'm putting the word care in quotes, that they could not speak out. It was the intervention of a social activist. I'm like bringing the intervention of civil society also through this journey. It was the intervention of a social activist who came and said that, no, they are looking, the accused is in front, so they can't speak. And that is why in that case, we didn't have the concept of screen and all that as it is today in POCSO. So in that case, they have asked the children to be in the front and the accused to stand back, so that the children don't see the accused when they speak to the court. So this is how it has all begun, very, very gradually. Then you had the great 1992 year where CRC was there. The Convention on the Rights of the Child came in. An absolute departure. We were thinking that children, we do charity to them, we do welfare to them, or they are beneficiaries of what we give. But 1992 made them rights holders. The approach has completely changed. I would like to, and that is why in the POCSO Act, you have the best interest of the child. And I would also like to point out the best interest of the child, the factors that go into it. I do not see any of the judgments, rights of the child being mentioned, how the best interest has brought in. When you're analyzing the judgments, I think we should have looked at the best interest aspect of it. The violation of the rights that had happened, the harm that was done to the child when all this happened. Somehow this has not come through in the analysis of the judgment, nor has been mentioned in the judgments about what rights were violated, what harm was done to the child, and how this harm has been rectified. See, in many instances, just punishing the accused may not be in the best interest of the child. The child just wants the abuse to stop. The child doesn't want their own father or grandfather or uncle to go to the prison. So that may not be in the best interest. So what is the best interest has to be brought in. I'll quickly go into the other things that came in. I would also like to mean the pedophile concept was first brought in the public discourse through the Freddie Peets case. Before that, we said no pedophile here in India. Oh, this is a Western concept. We don't have such things here in India. And also, we had later the Sakshi judgment. The Sakshi judgment that came in brought in a lot of guidelines relating to putting a screen, giving the questions to the presiding officer, giving breaks to the child, a lot of sensitive things. And these are something that has come in the POCSO legislation later. We have a law now rather than just guidelines. And then you had the 172nd Law Commission report with a lot of reform on the laws that were there. I would like to say that the 2007 Government of India Department of Women and Child Welfare Survey also played an important role in the journey towards the POCSO Act. That was the very large, comprehensive study that was done. We had small studies done by NGOs in various parts of the country, and also academic institutions. But 2007 Government of India DWCD report was a very, very hard-hitting report, disturbing report, which brought to light boys were abused, girls were abused, and the percentage that came in, I think almost 12,500 children were there in that, and about 13 states they had covered. What I would like to say before that, you must be all recalling that, my boys are never abused. They had that impression. And also that we don't allow our children are safe at home because it's that dirty old man lurking in the corner who abuses a child. No, even the Vidhi report also says, the NCRB report, time and again, various studies have shown that 97%
Family members.
97% of the people are known to the child. They are from the family, they are from the relatives, neighbors, teachers, friends, all those kinds of things. I would like to quickly share towards the end some institutional abuse examples in which I was personally involved. The first case was of a priest, I can say, a priest, a clergy who used to molest the girls who were sending. He was the director of an institution where children were there, orphan children. So he used to molest the girls when they used to go to him for disciplinary action or for treatment. Now, that institution was running without license. A social worker pointed this abuse out and because of this social worker who pointed this abuse out, a committee was formed and PIL was filed in the court. And as a member of the committee, we went and met that person. And a FIR was filed under Section 354 in the police station. And he was very casual about it when we spoke to him, very casual. He was arrested, released on bail, because at that time, we didn't have some stringent positions like POCSO, where he would not have been released on bail. He would have been punished if POCSO had been there. But that time, the case went on, he came out on bail. The second case was of these street children in Bombay. You have we have a gateway of India where there are street children roaming around. Now, these two foreign men, foreigners they were, British foreigners, who used to lure these street children through various expensive gifts. And these children, since they're staying and giving a shelter to children in a place like Bombay, street children, is not very easy. It's very difficult for children to get shelter, people to care for them. They were very scared. They didn't know what to do because they were being regularly sexually abused. They approached a journalist. And this journalist, because she used to, they knew her because in that area she used to frequent, she used to stay nearby that area. They went and approached her. She put them in touch with some social activists. And we interviewed those children. An FIR was filed in the police station and a case was registered and action was taken against them. And I would also like to say that Yes, it did take time in this case. The children have had by the time the matter came up till the Supreme Court, there were a lot of discrepancies in the evidence in the testimony. But I would like to say that this kind of issues we need to take care of, that if there is so much of delay, testimonies differ because the children were by then grown up also, and many of the things they had forgotten.
Right.
Anchorage case was the other case in which I was personally involved. And in that, there were sodomy cases. In that, there also these were people who were working, children who were working. They wanted shelter very desperately, and they were being abused, sodomized by these people. When we went and visited those children, I remember they were all very in need. Too much financial need. Poverty was the issue in this case. They told, when I spoke to those two men who were running that place, I said, I found the bathrooms with no doors. So when I asked, why are these bathrooms with no doors? They said, at least I'm giving them bathrooms. In your country, they don't have bathrooms and everything is done in the open. That was the answer. That was the casual answer, very casual answer. The last case that I would like to mention is about special children, intellectually disabled children, in which this was a suo motu PIL in the Bombay High Court. It was in August 2010. Suo motu PIL, and it was based on a newspaper report which said 5 children had died of starvation in an institution. But when we went and met the children and the CWC was brought into the picture, medical examination was done, all of them mostly were sexually abused, regularly sexually abused in that case. Now, this matter went up till when it came to the court, stringent punishment were given. Stringent punishment were given to them. And this was a case in which we need special educators, we need a psychiatrist, we need psychologists. There was no POCSO at that time, 2010. So we had to give Sakshi judgment and Gurmeet Singh judgment to the PP, saying that you'll see this and see that things are followed according to these guidelines that are there. And they were followed in that case. Strong the punishment was given. There were 2 cases. In one of the cases, strong punishment was given. And while giving the punishment, ranging from 6 years to life imprisonment, it was given. One of the children gave evidence in sign language also. We had an interpreter there, sign language expert there. And and while giving the stringent punishment, the court said that the children were subjected to such torture, such form of tortures, that they could not raise their voice against the people torturing them. And this sentence, this strong sentence, should send a correct message in the society. I'd like to end there. And whose words are these? Justice Joshi.
Thank you so much for that quick. Truly, it was a crash course in legislative history on POCSO. Thank you for that. But truly, it tells us how far we have come, which is equally important to take note of, ranging from child-friendly measures in the way the case itself is conducted, to being mindful of how to view the case from a child's perspective instead of how an adult perhaps looks at modesty or sexual abuse. What is it that happens to the child, and how the investigating authorities and the courts, every stakeholder needs to be involved at every stage of a trial. That is perhaps what POCSO brought to this country, and it needs to be carefully guarded. While the data does paint a bleak picture, it is important for us to know that behind that data, especially with what you said, in terms of certain cases resulting in different kind of decision making because of the way the law itself is worded, that those things need to be read together to ultimately make sense of what needs to change in the underlying legislation. But this impact evaluation of a legislation will happen only if we have data, as our presenters very strongly indicated. And that is where I would like to bring in Mr. Damble, who has unfortunately, like us, struggled with judicial data very regularly. One of the data points that was highlighted, Mr. Damble, was how out of 112,000 cases, we were able to tabulate 717 different outcomes. And we all know that POCSO does not provide for those many outcomes, right? So given the inaccuracy at some level, lack of comprehensiveness at another level, how do you think underlying framework can change when it comes to data management in the judicial system so that assessments such as this become a regular feature?
I think the origin of the whole thing is that we are not looking at the disclosure of the data from the same point of view. So there is one element of it where the courts, I presume, are coming from right now is transparency. They want to know that this is public data and you're putting it out to the public. But behind that thought isn't this consideration that we are putting it out in the public so that it can be used on scale. So when you have that thinking in mind, when you're thinking about putting out data for research, then automatically some things start falling into place. So for example, what is a case is not something that every state has uniform rules on. So if you, and I'm sure the Vidhi team also noticed this, is that you won't consistently find every POCSO case labeled as being a POCSO case. It could be some states can go, or even within a state, there can be some variation where some states just label a proceeding under a procedural law. It'll be CRPC section something. It could be IPC section something without the POCSO part being mentioned at all. And then that creates some difficulty in first figuring out what is the universe of the data set that we should be dealing with in the first place. So that's the first level, which is the availability of the data. The second thing is the access part of it. So right now, because again, the lens that the courts are viewing it from is transparency, it's not easy to access data on scale. So even when you have the technical wherewithal to write code for scrapers and whatnot, it can take months to actually get the data from the e-court system. So that has to be one other thing that the courts have to think about going forward on how to enable bulk access to data. And the third part is usability, which is once I have access to data and once it is available for all of the jurisdictions from where we are supposed to get it, can I actually use it easily for whatever purpose that I need to? Now here there are some competing interests that we have to account for. So for a researcher, I would love all the data to be classified nicely, cleanly with all of the tags that I am interested in marked on the case. But that's one, not necessarily in the interest of the judiciary, and two, it's maybe not obvious, or for that matter, it's not useful at all for the judiciary to do it. So there has to be some sort of middle ground we find in terms of how usable that data is. And there actually, if you think about it, it's a chicken and an egg problem. Until somebody does a study like this, the court is never going to recognize that putting out data like this is important in this manner and so on. And until these kinds of studies are actually conducted, we won't be able to figure out where things are going wrong. And just to sort of highlight the problem with usability of the data, we just heard from all three of our experts that actually, Dr. Bajpai mentioned is that 97% of the case, in 90% of the 7% of the cases, the abuser is actually a member of the family. But if you look at the data that the Vidhi team was actually able to harvest from the judgments that they read manually, they found that 44% of the judgments they aren't detailed enough to actually figure out who the perpetrator was. And this shows you where the gap is in terms of what is being put out and what needs to be put out. So that is one side of it. This is the courts dealing with data. So if we sort of zoom out a little bit and think about it from a meta angle, what are we really dealing with here? We want to figure out what is happening in society around us, right? But do we know, do we have any system to gather data on crimes being committed reliably? We don't. To my knowledge, there is one large recent comprehensive crime victimization survey, which was, I think, in 2018 or 19, which IDFC had done. I think it was called Satark or something. So they found out, in fact, that in their sample set, which was some 5 cities, only 7.2% of the respondents who are victims of crime actually filed an FIR in relation to that crime. So this brings up the question again of, are we really studying the criminality or are we studying the administration of the court? And by no means am I saying that that's not an important question to pursue, but it just puts things into perspective in terms of how far we still need to go. The last thing is, okay, what do we do about this?
Right.
So do we just say to all the courts, look, there is too much variation in what everybody is doing. We are not able to make sense of anything. From now onwards, this is the format and you follow this. I'm a little hesitant to say that that is the solution, because if any of us here have read James C. Scott, Seeing Like a State, there could be some underlying logic to why states have organized their bookkeeping in the way that they have. And forcing something from the top down uniformly might actually end up putting sand in the gears instead of helping it move ahead. So maybe we have to think a little stepwise. We start with something like having a standard for recording the data. There are some things that you must record. We don't go beyond that. And then we make step-by-step incremental additions to it. Because we are not just changing technology, or the technology already exists. There is a cultural change and an administrative change that has to happen. So we have to think really about that. On the administrative side of things, there are several solutions which have been thought about. One fairly convincing case to be made is to have a dedicated administrative service like you have in the UK,
Right.
the HMCTS or the US administrative courts. That is worth looking into, in my opinion. And the where was my last point? I'm really sorry. Yes, so this is the administrative side of things. The other is that we have to recognize that we're dealing with institutions with a huge amount of inertia. So if you look at where this digitization process even began, if you go back beyond 2014, data practically doesn't exist on e-courts. So we have to recognize that this itself is quite an achievement for an institution which is so ancient, so to speak, in its practices, which relies so much on tradition and precedence. So one message is, let's not get disheartened. And the second is that we have to do this in very small steps, because otherwise we'll end up disrupting this too badly. The last piece is we have to also be careful about jumping to conclusions about what the solution to things is. So one thing, and this I say, because usually the solution to anything seems to be make special courts, make fast track courts, increase the number of judges. And again, not saying that is not going to help. The problem is that until we solve many other things which feed into it, the capacity building for all of the ancillary processes that are involved, the administration in general, we might end up in the same process, in the same state where it takes years and years and years for cases to get disposed. And there even is some evidence for it. Daksh did a survey on this in Delhi on pendency-free courts. What they found is that even if you started courts with zero backlog, within a few years they caught up to the same level of pendency as the courts which are already there.
Right.
So those are my few thoughts on this.
Thank you so much for that. As in, it was a very comprehensive response, and I think one point on which I may digress a little is how the objective of the judiciary right now is transparency, but it needn't necessarily be limited to that. I think what is necessary is for the judiciary to view itself as a deliberate stakeholder in policy making. Of course, we know about separation of powers. We don't need to go into that debate, but for the judiciary to be mindful of the fact that its judgments, the trends that emerge from its judgments will actually go into policy making, will actually lend themselves to future legislation making. That in itself, that kind of awareness in itself will perhaps nudge a judge to record a few more details in the judgment that will perhaps help researchers such as us and policymakers to make a more informed decision, knowing what the ground realities are like, because judgment ultimately is a mirror to what is happening in the society. So going forward, hopefully that will feed into how data itself is thought about within the judiciary and how that is made available to the general public. I'm mindful of time, but there are just so many points that I know we need further discussion on. While I have my list of questions, and I know the panelists also have quite a few points to make, I would like to open it up for audience for any questions for the next 5 minutes.
I just have a suggestion. I just have a suggestion. When you find it difficult to access data because a case is to be found only under a provision of the CRPC or only under the provision of IPC, it's not supposed to be like that. All the provisions are supposed to be mentioned. So when you come across something like this, maybe you can draw the attention of the Supreme Court E-Committee to it. And that would help things.
One of the largest debates was punishment under the Act and whether death penalty should be awarded, and that was a debate that was in public discourse 2 years ago. But my question really is, let's say, for example, a 3-year sentence is awarded, and the perpetrator moves out after that, the child continues to be exposed to that. So is really the way to go, act like POCSO? Is it imprisonment or is it the reverse? Is it a way? Do we have to find a way to protect the victim instead of punishing the perpetrator? And how do we deal with that?
Thank you. Can we take the next question as well, please? Second row.
My question lies with Captain, we're talking about delays. Section 309 CRPC of the provision of sexual offences should be tried within 2 months. Whereas POCSO being a special legislation, I think
That is 1 year. Aren't both the provisions somehow contrary? And I also have second part to my question, which has always bothered me. Considering we now rely on the sole testimony of the victim, is basically one person's word against the other. How as judges do you decide whose word to trust?
Thank you for that. One last question before we move to responses. Right?
Okay. Good evening, everyone. My question is there's one gray area that all of us have failed to address, which is the difficulty in getting bail in the POCSO cases, because there's section 29 which provides for presumption of guilt. And a lot of time this happens that the courts invoke this at the stage of bail itself before even the formal charges are framed. So this is being invoked, and ultimately you're asking the accused person to put forward his best defense even before he's aware of the charges, formal charges that are supposed to be framed against him. So this fundamentally we're in a state of we're kind of ignoring the fundamental rights that are given to an accused person. Is that he cannot be asked to put forward his defense before he's aware of the case against him. So this is happening a lot of time. Recently, the High Court of Jammu and Kashmir has said that the contours of section 29 would come into picture even before would apply to a bail application moved before the trial commences. Essentially, the High Court has ignored everything. They're asking the person to disclose his defense. And this also results in a mini trial being conducted at the stage of bail itself. So this is fundamentally a very big issue that needs to be addressed. And what is the opinion of the panel on this?
Sure.
Stage there is no trial. One looks into the prima facie materials which are there. There is no trial at the bail stage. What the court looks into is the prima facie, what are the materials which are there.
If the presumption comes into picture, ultimately the accused person has to rebut the presumption. And how a person who is just charged with who's been booked under POCSO, how is supposed to rebut the presumption? He does not have any material, he has not been supplied with the charge sheet, he has not been given anything. How a person is supposed to rebut the presumption then?
The court looks into it. The court looks into it. The case diary is produced at the time of bail.
Rebuttal of presumption is only at the time of trial. And there are divergent views of various high courts. Some high courts are saying this presumption can be considered at the time of deciding bail applications. Some high courts are saying no, because that can be considered only at the time of trial. We have to get to an authoritative pronouncement from the Supreme Court on this aspect. But as ma'am has said, the presumption we look at only at prima facie, and as a judge, who is deciding the bail application, he has entire material which accused may not be having. Like suppose the accused is having the defense that it is a romantic relationship. The material before the judge will display it, because there will be WhatsApp messages, there will be emails, there will be photos. So the judge, or the statement of the victim girl. So it is not that judge is not having anything before him. So prima facie only it is considered, and not at the threadbare considered. So don't be afraid on that issue.
Yes, please.
One of the questions last, I think. About the child's protection that you had asked for. Yeah, we need a witness protection, witness victim protection scheme, very, very strongly implemented and very seriously implemented. Some states have, but still somehow we need a national victim witness protection scheme. Children need to be protected as victims and witnesses. Even it should be mentioned when the judgments are being made that this child needs protection, not before trial, during trial, but even after conviction. See, when the conviction has happened and the accused are in the prison, now when they're about to come out, for instance, 10 years, 11, 5 years, the children, where they are, they must have moved on. But still, in some cases, they are scared that when the accused come out, what will happen to them? We need a victim witness protection scheme very, very strongly and very, very urgently. That is required. And as far as the protection is concerned, every case that comes in, we need to do a needs and a rights assessment for each case. When you do a needs and a rights assessment, this will focus on the child and the child's protection rather than on the accused and punishment to the accused.
Thank you for those responses. Just one last question, and then we can perhaps continue the conversation after the.
My question has not been answered, sorry.
Could you repeat the question in like a sentence so that one of the panelists can take it?
My question had two parts. Sorry, I would want to pose both of them again. First is regarding Section 309 CRPC, which provides for 2 months, whereas POCSO, which provides for 1 year. So there appears to be discrepancy when the special law is, actually the general law is better than the special law in terms of timely trial. And second is regarding the sole testimony of the victim being relied upon, wherein like it's basically one person's word against the other. So how do you judge?
About sole testimony, Gurmeet Singh versus State of Punjab has laid down that law in the year 1996 itself, but it is with a caveat, provided it inspires confidence in the judicial mind. So judicial mind is trained, it's seasoned, it is mature. So we know how to, as you said, one's word of one against the other. So we also seek supporting corroboration sometimes, even if it is a sole testimony in case of children, there is always the medical evidence, there may be forensic evidence, there may be some other supporting evidence like spot panchayama, then the medical examination of the accused showing some signs of sexual, assault having been done. So there are circumstances. It is not exactly sole, but when such situation arises, we know whom to trust and whom not to trust, whom to rely upon, whom not to rely upon, because it is a matter of experience. It is a matter of training. It is a matter of every day doing that job again and again. So, it is not so difficult as such, because the caveat is it should inspire confidence in the judicial mind. And that is most important. If I find you reliable, then only I will convict, otherwise not.
There are also certain other factors, like would there be any reason for the victim to falsely implicate the other person? Was there any pre-existing dispute family dispute, monetary dispute. Those things are also looked into.
Several factors are looked into. So
And even there are judgments which say minor discrepancies in such cases should be overlooked.
Yes,
Right,
yes.
right.
minor discrepancies.
Yes.
And this is a specific progress made keeping in mind the nature of the witness in front of the court, right? The child witness and the nature of offense itself is such that it mostly happens in private without any corroborative evidence. So I would see this as a progress as opposed to something which is a matter of concern. But as the judges said, it truly takes a trained mind to identify what to rely on, what and what not to. One final question, because it's already 20 minutes over time.
Another question still remains. There is inconsistency in the general law, criminal procedure code, and POSCO Act. But why it is that is the legislative area. But even under the POSCO Act, what is important? Entire POSCO Act, is founded on the testimony of the child. So that we insist on recording within 1 year. POSCO Act provides 1 month. So there is not much. Rest of the evidence can be even considered, within 1 year. But yes, there is a discrepancy, but that is for the legislature to take note of.
Are we done with all your questions? Okay. One final one, please.
Hello, everyone. My name is Sunaina. My question is directed to Mr. Anant Asthana and Professor Bajpai. So it's a two-part question. I fail to see the implementation of the POCSO trial, which needs to be carried out even in the Juvenile Justice Board. And further, this is what I have noticed, that all the stakeholders fail to understand the complexity of the mental assessment report, whether it may be of the victim or whether it may of the CCL or the alleged accused. So what would be your comments? Because this seems to be missed out from all our discussions related to POCSO. Thank you.
I think your concern is very legit, and in large part of the country, a huge set of benefits which POCSO provides are not made available in cases which go before JJB, to the extent that the JJBs are actively discouraged by the judges who hold POCSO courts or the district judges that you don't exercise these jurisdictions. For example, in many states, despite several high court judgments, JJBs do not dare to grant victim compensation, because if you do that, the retaliation comes from the superior judges, because victim compensation is seen as something which only senior judges can grant. So across country, cases which go to JJB, victims have great difficulty having access to victim compensation. So that's a great concern, and thank you for pointing it out, because entire focus is going on POCSO courts. While a large number of cases are landing up in juvenile justice boards, and you can get the data of POCSO courts on e-court, JJBs are completely inaccessible. You cannot have any idea what goes on in JJB. So thank you for doing that.
So what I've observed is also that a trial fails to start also in the JJB. Even in it takes more than 1 year sometimes. The PIL is not filed, or the psychological assessment of the CCL is not filed, and various evidences are not recorded or filed.
POCSO courts are headed by judges who are at the rank of session judges, right? Very powerful judges. JJBs are metropolitan magistrates or judicial magistrate first class. System doesn't care about them. So even if they want, the police officials do not bring charge sheet at all. The same struggle in a session court judge. Of course, the public prosecutors will be very senior. Here, the junior most public prosecutor is put in the JJB. Sometimes there is no public prosecutor to put any kind of pressure on the. So, of course, the situation in the juvenile justice boards is really, really bad. I hope some attention is given on that part because a large number of cases are going there. Other part, I think,
Only
thank you for flagging this. This was completely missed.
Only cases where a child is in conflict with the law will go to the JJP. POCSO cases will not ordinarily go to the JJP.
Sorry, ma'am.
Special court, they will go to the special courts.
For 2 years, I participated in engaging with children who were victims of POCSO as a support in the capacity of being the support person. I had various cases enlisted in the JJB, where I would say that there was one, I would point out to one particular case where a 14-year-old...
The perpetrator was also a child.
Yes, ma'am. Where a 14-year-old boy sexually assaulted a 5-year-old girl.
Yes.
And
Then it
various
would be
other
in the
examples.
This thing about mental assessment that has to be done, because in cases of serious heinous offenses that come before the Juvenile Justice Board, where the accused is between 16 to 18 years, and a mental health assessment or psychological assessment has to be done. I mean, this is an area that needs some kind of attention, a review, because what is happening is this whole thing is not in compartments, it's a package, as was mentioned initially in the initial introduction, that it is a package. By Deepika, it was mentioned. You can't have mental health experts on their own coming, or counselors, social workers, support persons. It's a whole, stakeholders, so many of them, PPs. We need a kind of a coordinated training for all of them so that they understand what the others are, roles are, and what the whole objective and the spirit of the POCSO Act is. Somehow we have compartmentalized this. Every expert comes with its own ideas and old perception and old perspectives as far as children are concerned. We need specialized training as well for them, depending on the groups they are in. But we also need trainings which are coordinated, which are interdisciplinary, multidisciplinary, all the actors and stakeholders together.
Nowadays,
it is being done.
There is a support person.
Yeah.
And all the questions are put through the support person.
Yes.
And then it is the support person who's talking to the
if required,
if required.
And
it is being done technologically, where the victim cannot even see the court sometimes. He can neither see the judge nor see the perpetrator. And all the questions are usually put at the same time once it is
in a simple manner, in the language which child can understand, and they are put by the judge, not by the defense counsel, so that the process is made somewhat easier, less traumatic. But otherwise also, to relieve the entire trauma for the child is very, very difficult, to repeat whatever has happened again and again. And I used to conduct these cases, and I know the trauma faced by the child. And it is not only the child, but all the stakeholders, even for judge, for public prosecutor, for defense counsel, everyone has this, as in the study report also they have highlighted, it is a vicarious or trauma which everyone faces while conducting these trials, because no one wants a child to be in any way abused, exploited, and then such a child again to be called as re-victimized or further victimization, because child has to recount again and again. That is really traumatic experience for everyone.
Thank you, Justice Joshi, for bringing that point to light, because oftentimes we talk about, as we rightly should, about the central actor in this entire ecosystem, which is the child, and we need to be thinking about the best interests of the child. But what we also end up perhaps ignoring is the impact that the case, the facts of the case, which often leaves an impression on various stakeholders, ranging from support persons to the judges themselves, who are affected by hearing these cases day in, day out. Vicarious trauma of judges, unfortunately, is a very understudied issue in the Indian legal system. We do hope to take that up in the coming months as a specific topic to focus on, and hold a few consultations. But on that note, we will unfortunately have to end this very engaging discussion. I must thank all of you for patiently sitting on, despite it being nearly half an hour beyond the allocated time, and for all the panelists and Justice Banerjee for patiently answering all the questions and making this a very enriching experience for all of us. As we had said, this report is a starting point. We are hoping that what data tells us can be corroborated by anecdotal evidence and ground realities that all the stakeholders bring to fore, and only then we will be able to make sense of how POCSO has fared. With that, we will bring this panel discussion to a close, and I would request my colleague Shreya to give word of thanks.
Before we close, can I flag one more concern about the POSCO Act, that it is not made applicable to mentally or intellectually challenged children who may be having the mental age of, 6-7 years, but physical or biological age above 18 years. And
Right.
these are the children who really need the protection in the entire trial and investigation process. But for them, the POSCO Act is not available. There is judgment of Supreme Court in Ira versus State of Delhi. So this is an area which should be really taken forward when we are talking about the amendments in the law. This concern should be also flagged. That is what I really feel necessary, because the law is meant for them. They are in the most need of the law, but unfortunately no. But thank you so much for allowing us to voice so many concerns.
Yes.
Thank you, Deepika.
Thank you so much, all of you.
Good evening, everyone. It gives me great pleasure to deliver the vote of thanks today. On behalf of the Jaldi team, I would like to thank Honorable Justice Indra Banerjee for the very insightful keynote address that she delivered for the event. It has been an absolute honor, ma'am, to have you here. We are also extremely grateful to all the panelists for sharing their knowledge and experience with us all. The team is also very thankful to Ms. Swagata Raha and her colleagues at Unfold Proactive Health Trust for taking out the time to review the report and to give us their insights. We would like to thank the de jure team and the team at World Bank and all our interns in de jure as well as Vidhi. They have been an immense support throughout this report. Especially, we would like to thank all of you who are here physically and people who have joined us virtually for taking out the time to join us. This is the first physical event that we as the Jaldi team have had post-pandemic. So we would like to thank the comms team and the admin team at Vidhi for all the support during the event. Thank you so much again for joining us.